In November of 2022, Zane Lumpkin ran a red light while driving a stolen pickup truck. He crashed into another vehicle and fled. Officers found him impaired and he was arrested. He was charged in Superior Court with possession of a stolen motor vehicle, and his trial was set for January 9th of 2023. At the same time, a separate set of misdemeanor charges, including DUI, hit and run, obstruction, and others, were filed in district court. However, his defense did not try to combine these with the felony case, even though the charges were clearly connected to the same incident. As the felony case moved forward, it was postponed till March 6th of 2023 to allow for more evidence. The state wanted to add additional felony charges such as vehicular assault, DUI, and felony hit and run, but they were waiting for the toxicology results. In the meantime, the misdemeanor charges were dismissed without prejudice, meaning the state could refile them later. On March 6th, Lumpkin went to trial and was convicted of possessing a stolen motor vehicle. On March 26th, after receiving the toxicology results, the state filed new felony charges, DUI, felony hit and run, and vehicular assault, all based on the same crash back in November. Trial for these new charges was set for May 30th. Lumpkin's defense objected. They argued that these new charges were related to the original stolen vehicle case and should have been tried at the same time. Under Washington's time for trial rule, Lumpkin claimed that the state had run out of time to prosecute him again for charges tied to the same incident, but the court disagreed. The judge ruled that the time for trial had not expired and denied Lumpkin's motion to dismiss. The case proceeded to trial on the new charges, and on June 13th of 2023, Lumpkin was convicted again. Now he is appealing his case, arguing that the state should have tried all the charges together and that they waited too long to prosecute him the second time. He also argues the victim penalty assessment should be struck from his judgment and sentence because of recent legislative changes. Let's take a look.
Dennis Morgan appearing on behalf of Zane Lumpkin, and I'm going to reserve 5 minutes if that pleases the court.
Very good. Go ahead.
Thank you, Your Honor. Mr. Lumpkin's before the court on a kind of a unique issue, and it pivots on the definitions of various phrases that are set out in the court rules. And in connection with those court rules, which deal with time for trial and mandatory joinder, the trial court, when it entered its findings of fact and conclusions of law, determined that these offenses that are before the court today were not related offenses to a possession of stolen motor vehicle charge that was made separately. And it did that based upon using same criminal conduct from the sentencing statute, which has no application whatsoever to the definitions involved with what are pending charges and relating charges under the time for trial rules, or the same conduct analysis under the mandatory joinder rules. So what we have here is the trial court using the wrong basis for making a determination on whether or not these were related charges.
What is the correct basis for determining related charges?
The correct basis for that, I submit, is still State versus Peterson. It has not been overruled. It does predate the amendments to the rules that occurred in 2003. But I have not been able to find a case other than the Canfield case, which is an appellate court case, that even discusses it closely. And that came down here, I think, in 2022. The last Supreme Court case that I have found relating to same conduct and saying Peterson's still good law predates 2003. And it is not included in my brief. I just found it the other day, and I will send up an additional statement of authorities on that. It's State versus Watson, 146 Washington 2nd, 947, 53P 3rd 1. It's a 2002 case. And I think it's pretty clear. The Supreme Court has not changed this ruling. Offenses are related if they are within the jurisdiction and venue of the same court and are based on the same conduct. Same conduct is conduct involving a single criminal incident or episode. That's exactly what we have here with the underlying facts involved in Mr. Lumpkin's case. And
Mr. Morgan, just point of clarification here. You're not arguing that this issue is governed by the mandatory joinder rule under 4.3, correct?
That's correct. Trial counsel on this matter said very clearly, I'm not arguing mandatory joinder, I'm arguing time for trial.
Okay, so you're arguing that the related charges under A5 is what we should be using, correct?
Yes,
Okay, so and just so that I understand, you contend that the charge of possession of stolen motor vehicle and then the separately filed felony driving charges are all related charges.
that's correct.
Okay, and so it's your argument that 3.3A5 dictates the time for trial calculation in this case.
That's correct.
Okay, let's assume you're right. In the briefing, did you put forth a computation of time under that rule?
No, I didn't. And the reason I didn't is if they were related charges, and they are related charges from Mr. Lumpkin's viewpoint and mine, the situation is that the possession of a stolen motor vehicle went to trial on March 6th of 2023, I believe it was, found guilty on March 8th of 2023. Then on March 21, the state filed the charges that are before the court now. So there was nothing to compute as far as the time for trial is concerned because they're related charges. And because they're related charges, they couldn't even bring the charges.
So,
okay.
Let me ask you something then. A5, 3.3A5 says the computation of the allowable time for trial of a pending charge shall apply equally to all related charges, correct? So it's not just the commencement, it's the computation. So I guess I don't understand here. First of all, your argument is that the time for trial on the felony driving charges commenced on November 15th when they filed the possession of stolen motor vehicle, correct?
I believe it was filed, the possession of stolen vehicle charge, I submit, I believe was November 8th. November 15th may have been
his arraignment.
Arraignment, yes.
Okay. So that would be commencement date, correct?
Yes.
Okay. And then on November 15th, they set trial for the 9th of January, which was day 55.
Yes.
And then they continued that to March 6th, and that would be a tolling continuance. So when trial commenced on the possession of stolen motor vehicle was on day 55, correct?
Right.
Okay. And then under subsection E5, it says when commencement of the trial on one charge, the time between the commencement of trial on one charge and defendant's arraignment on a related charge is tolled. So when they started trial on 3/6, between 3/6 and arraignment on the related charges, there's no time, correct?
I didn't look at E5. If that's what it says, that's probably correct.
It says, let's see here. The period between the commencement of trial or the entry of a plea of guilty on one charge and the defendant's arraignment in superior court on a related charge is an excluded period under 3.3E. That's 3.3E5.
That's kind of interesting.
So if that's the case, then when they arraigned him on April 6th and set a trial, he's on day 55.
That I agree with.
Okay, at least day 55. If he's on a 60-day trial, then they've got that additional 30 days. And if he's on a 90-day trial, then it's on day 55. Okay, just wondering.
So again, I think we've got to look at the language that's being used with regard to what constitutes a related charge. the trial court said these charges aren't related. They are related. They all arise from Mr. Lumpkin driving a stolen vehicle on November 4 of 2022 while he was under the influence of drugs, blows through an intersection and hits another vehicle, then flees the scene. And the interesting part of this also is that the state was fully aware of the existence of the vehicular assault charge, because they were contacted on November 6th by the person who was injured to advise them that she'd suffered a broken sternum. So I don't know why something sooner hadn't been filed there. If we have to also take a look-see at the district court charges, it appears from everything that the state made a determination they were just going to pursue the possession of a stolen motor vehicle in Superior Court, and then the district court charges were filed after that. The district court charges were never noted for trial. So that period between November 14 or 15, when he was arraigned in district court, to February 17 of 2023, can't be counted against him because there was no trial date set.
Mr. Morgan, are you arguing then that district court cases is what determines time for trial in this case?
Because the charges are related charges, yes.
But don't you have to, I mean, isn't it one or the other?
That was, I think, the horns of the dilemma that defense counsel was facing when he filed his motion. He decided to pursue time for trial. He didn't decide to pursue mandatory joinder. And the situation is that I submit that the state is the one that has to join the offenses. And the state lately determined, when it dismissed the district court charges on February 17, and they had already prepared and were ready to file in Superior Court an amended information that would have included all these charges with the possession of the stolen motor vehicle. But then they found out they didn't have the results on the DWI from the crime lab. So they didn't file those charges and proceeded to trial. But they did have those results before that trial actually commenced. So we've got all kinds of twists and complications in connection with what should have been done, what was done, and what now needs to be done.
Mr. Morgan, you're into your 5 minutes at this point.
I'll reserve.
Okay, thank you. Ms. Verhoff.
Thank you, Your Honor. May it please the court. Gretchen Verhoff for the state of Washington, Spokane County. The state respectfully requests that this court affirm Mr. Lumpkin's judgment and sentence in this case. His trial was timely under CRR 3.3, regardless of whether or not the charged offenses in Superior Court were related offenses to the possession of stolen vehicle. As Judge Staub went through the speedy trial rules, it's very clear that there is an exclusionary period for periods between the dismissal of a related charge and the refiling of that charge in Superior Court. And Mr. Lumpkin has not provided an analysis as to how that affects any calculation of time for trial. Returning to Mr. Lumpkin's contention that the burden is on the state to join offenses, I would refer to the court to the mandatory joinder rule 4.3.1, which actually indicates that the burden is on the defendant to make a timely motion to join offenses of which he is aware. And undoubtedly, Mr. Lumpkin, represented by counsel in district court and in Superior Court, was aware that he was charged with DUI and misdemeanor hit and run in district court, and could have made that motion. I think when the court looks at, I believe it's State versus Harris, I want to make sure I get the right. Yeah, it's State versus Harris, 130 wins second, 35. That case indicates that because the Superior Court has concurrent jurisdiction over district court matters, not municipal court matters, a motion for mandatory joinder can be made. That case was a taking motor vehicle without permission and a no valid operator's license misdemeanor. And so the court in that case said that those charges, even though they've been split between two different courts, since the Superior Court had jurisdiction over both charges, a mandatory joinder motion could have been filed. So I think that that undercuts Mr. Lumpkin's argument that this was on the state to move to join. I would also indicate that under the mandatory joinder rules, the state is excused from joining offenses for which there is insufficient evidence to proceed. At the time that the misdemeanor was pending, the blood results had not been received. Certainly, the state knew that those blood results were being tested. And once there was information, that probably the testing was underway, the state moved to dismiss the district court charge. I would also indicate, and Mr. Lumpkin seems to rely on the fact that no trial was ever set in district court under the district court rules. I don't think that that affects the time for trial because the district court rules permit the court to set trial at the pretrial hearing. And so Mr. Lumpkin's waivers of speedy trial, which occurred throughout the district court proceedings, would operate to keep that case at day zero. So returning to just the question that Mr. Lumpkin has posed here is whether or not these are related charges. I don't think it matters. I think that that's probably an academic exercise that the court doesn't need to engage in. But if the court does engage in that exercise, I would refer to the court to Kinsvogel. I think I'm pronouncing that correctly.
It's Kinsvogel.
It's Kinsvogel. Thank you, Your Honor.
The reason I say that, if you look at the attorney who argued that, I'm very familiar with that.
Okay. All right. Well, it's Kinsvogel, Your Honor. Thank you for the correction. I do appreciate it. So the court is well aware of what our Supreme Court said in Kinsvogel, and the Supreme Court really broke down what related charges are. And in referring to the ABA standards, the court said that related offenses are those offenses that are either based on the same conduct or from the same criminal episode. Same conduct is offenses that are based on the same physical act or actions. And I think that we see that in this court's opinion in Canfield. The same obstructing act was then parsed out into multiple different types of obstructing. But really, it was all the same act. The second definition is related to the same criminal episode, and those occur in proximity of time and place where proof of one necessarily involves proof of the other. And so based on that definition, if you look at the possession of stolen vehicle and the charged offenses that we're talking about here in this case, the vehicular assault and the DUI and the hit and run, those offenses do not necessarily involve the same proof. So these are not legally related offenses. I want to talk.
In Kinsvogel, wasn't another factor that the Supreme Court looked at is identity of the victims?
Yes, Your Honor, and I was going to get to that because I do want to talk a little bit about Judge Hazel's comparison of the related offense inquiry for purposes of mandatory joinder and CRR 3.3, and what we term same criminal conduct for purposes of sentencing. And even though the Court of Appeals in, I believe it was Kenyon, said that comparison is really no good, they're separate inquiries, I think what Judge Hazel was getting at was the court looks to similar things. The court looks to whether or not it's the same victim. The court looks to the elements of the offense and the proof of the elements of the offense. As in the same criminal conduct inquiry, the court would look at the criminal intent. The court would look at the time and the place to determine whether or not offenses are the same criminal conduct. So I don't think, while there is authority that says that the two shouldn't really be compared, I think it's understandable why Judge Hazel made that connection, because really they're very similar in nature.
Well, we review this issue de novo regardless, and so we can use our own language if we find Judge Hazel's language a little bit inaccurate.
Absolutely, Your Honor, and to that end, the court can also affirm the lower court on any basis that's supported by the record. So even if there was something in the court's conclusions of law that is inaccurate, this court can affirm on any basis, to include a separate speedy trial calculation, which is why the state has provided this court with additional court records relating to the defendant's incarceration on other charges. That's going to affect the time for trial.
So, Ms. Bearhoff, let me ask you, on that note, and this goes to the felony possession of stolen motor vehicle charge. Was he on a 90-day clock or a 60-day clock?
I believe he was on a 90-day clock, Your Honor, because he was held on the robbery charge.
But he was also being held on this charge, correct?
And he was being held on this charge.
Okay, so go
I
ahead.
was just going to say, the reason that I think that the robbery charge might be important is, from the state's perspective, if the court were to say these are all related charges, and so they really are on the same clock. The state wanted to provide this court with additional information that he was incarcerated on other charges and then subsequently convicted of those other charges.
So was he serving a sentence on that robbery charge or just being held pretrial?
Both, Your Honor.
Okay.
The conviction for the robbery occurred, I believe, at some point during the pendency of the proceedings, and then he was thereafter held on that.
Okay.
And typically when one is sentenced, one gets credit for time served. So one would think he received some credit for the robbery time he was in jail, but I don't know if the record reflects this.
And I'm not sure if it did. Probably, I think that the robbery conviction was the first in time, so he probably received all of the credit on that case, and then his credit on subsequent convictions may have been adjusted based on the time that he was serving on the robbery.
But we don't know.
But I don't know from the record. No. So ultimately, I do think that these are not related charges. And going back to Mr. Lumpkin's argument, there is no mandatory joinder argument here. So it's a little tricky because in Kinsvogel, the court really looks at both issues and says, well, if they're not required to be joined under the mandatory joinder rule, then there's no speedy trial violation. And it's unclear to me whether or not that means that if they're not mandatorily joined or required to be joined, that therefore they're never going to be related charges for purposes of the speedy trial rule.
Well, Kinsvogel was decided before the amendments to both 3.3 and 4.3. So at that point in time, joinder and time for trial were all meshed together, and then they pulled them apart, and they're now under separate tests. So Kinsvogel's
it's limited perhaps in its application, but I do think the definitions that the court uses for related offenses, I think that definition is still good. I think that sort of how it plays out regarding the operation of CRR 4.3.1 and CRR 3.3 might be a little different because of those significant changes to the statutes. But I do think the definition of related charges is the same. Does the court have any other questions of me?
No.
All right. Well, I would ask the court to affirm Mr. Lumpkin's trial was timely. Thank you.
Following these arguments, the court affirmed Lumpkin's conviction. Even if the stolen vehicle and felony driving charges were considered related, his argument fails because 1, he did not claim the stolen vehicle trial was untimely. 2, by April 4th of 2023, when the felony driving trial date was set, the 60-day period had not expired. And 3, Lumpkin did not object to the May 30th trial date, meaning he waived any challenge to its timeliness. The court was remanded solely to strike the $500 VPA from his sentence. In 2023, the law had changed to allow courts to waive the VPA for indigent defendants. Since Lumpkin was found indigent and his case is still on direct appeal, the court accepted the state's concession and agreed that the VPA must be struck from the judgment. Please let me know what you think about this case in the comments below.